If a railroad worker is diagnosed with lung cancer after 20 years of working on diesel engines, can he still bring a claim?
Well, fortunately, the Federal Employers Liability Act, often called the FELA, has what's called the discovery rule. It means the 3-year statute of limitations that applies to bringing a case doesn't accrue or begin until the worker knew or should have known that their disease, here cancer, was caused by working for the railroad. So if they worked for the railroad for 20 years, and then let's say 10 years after they retire, they get lung cancer, the law still allows them to bring that case as long as they bring it within 3 years of when their doctor first diagnoses it, or when a doctor causally says it was caused by you being exposed to diesel exhaust fumes at work. So unfortunately, this type of claim can arise even after a railroad worker retires and strike them later.
Did the railroad, or does the railroad know that the diesel engine cause this kind of injury?
Well, not only did the railroads know that this diesel exhaust smoke and fumes was causing bad things, the railroad industry tried to suppress medical journal articles, and they tried to suppress reports that the EPA and other federal government agencies were trying to report by tying them up for years in court. So if that's not knowledge of a problem, I don't know what is. So the answer is yes, diesel exhaust fumes have been known to increase the rates of lung cancers in railroad workers that were exposed. Now, railroad workers who were cigarette smokers during their entire career had actually a higher chance of getting lung cancer, but it's a little harder for us as lawyers to prove if the diesel exhaust led to the lung cancer or if the cigarette smoking and the diesel exhaust may have caused lung cancer. But this is something we do as lawyers, and we can help a potential client sort this out.
Thank you.